Did you know that not everything you own goes through probate when you pass away? If you plan correctly, some of your biggest assets could completely bypass probate court, and understanding what those assets are, that could mean either a smooth transition or a legal headache for your loved ones. I'm Mitch Greene, an estate planning attorney here in Florida. Many people think that probate is unavoidable, but that's just not true. With some planning, many of your assets can pass directly to your loved ones without ever stepping into a courtroom. If you're reading this on the blog, scroll down and share it with someone navigating estate planning or settling a family member's estate. It could save them a lot of time, money, and stress. Let's break down the assets that typically don't have to go through probate and why they matter. First, jointly owned property. This is common among married couples. If you and your spouse own your home together and one of you passes away, the surviving spouse automatically becomes a sole owner. No need to involve the court. But here's the key. It only works if the title is set up properly. Just because you're both on the deed does not guarantee this protection. However, in the state of Florida, this is less of an issue, as jointly owned real estate between a husband and wife is presumed to be held as tenants by the entireties. Next are payable on death or POD accounts. These are designations that you can make with your bank or financial institution. For example, if you have a savings account and you list your daughter as the POD beneficiary, that money goes straight to her upon your death. No probate needed. It's a quick and inexpensive way to ensure that your money ends up in the right hands without waiting on court approval. Next is life insurance policies with named beneficiaries. A lot of people don't realize this, but life insurance isn't part of your probate estate unless you name your estate as the beneficiary, and that's usually not a great idea. If you've named a person or people, that payout happens quickly and privately. But, and this is a big but, if the beneficiary passes away before you and you have not updated the beneficiary designation on your life insurance policy, the money could end up in probate anyway. Next are retirement accounts like IRAs and 401ks. Similar to life insurance, these pass directly to the person or people that you have named. However, one mistake I often see is not updating those beneficiaries after a divorce or a major life change. If your ex-spouse is still listed, they may be legally entitled to the funds, even if you had no intention of leaving it to them. Finally, our revocable living trust assets. This is one of the most powerful tools for avoiding probate altogether. When you create a revocable trust and you properly fund it, meaning you actually transfer your accounts, property, and other assets into the trust, you no longer personally own those assets. They're now owned by the trust and managed by a trustee according to your instructions. So when you pass away, the trust continues to operate, no court intervention needed. But the trick is in the setup. A trust that isn't properly funded, that's just an expensive piece of paperwork. Let's discuss whether you want to protect your assets and loved ones and avoid the long, sometimes stressful, and potentially costly probate process. I'm Mitch Greene, and I do estate planning. Schedule a consultation today. And if you found this video helpful, please subscribe and share it with someone you care about. Planning isn't just thoughtful, it's a gift to your family.